Hi folks, Louis Martin again. This time I'm going to talk to you about mens rea. Mens rea is one of the elements of criminal liability which is based on the mind, the fault element. This is arguably one of the most important elements of criminal liability. So in your exam, having looked at the past papers, you are required to know the different types of mens rea because there's a hierarchy. At the top of the hierarchy, and most obvious and somewhat more easy to prove for the prosecution, is where a person has a direct intention. It's pretty clear, and the person's aim, desire or objective is to commit the crime. So they've got like a high level of mens rea. They've got like a specific desire to do something. And we see this with like specific intent crimes, such as murder, section 18, wounding with intent, theft, burglary, robbery. So those types of offences require the highest form of mens rea or guilty mind. Underneath that is indirect, or sometimes referred to as oblique intent. This is where a person has a purpose or a desire to do something, and something else happens which is virtually certainly going to happen as a result of their actions or their conduct. So there's quite a bit of debate around this indirect intention, and the courts tend to use the term the virtual certainty test. And this relates to where the jury can find evidence of a person's intention by assessing whether it would be virtually certain to occur, the outcome would occur. Then we deal with recklessness. This is where a person enters into like a risk-taking state of affairs. So this revolves around risk-taking, where a person knows the risk that goes on to take it. And then negligence. So negligence we normally find in civil law, but in criminal law, where a person's behaviour is so bad, so gross, it moves from civil into criminal. We mainly see this with the gross negligence manslaughter. That's the duty of care when the care is breached. And the breach is so gross, so serious, it becomes a criminal matter. We also then have strict liability. Strict liability is where the prosecution do not have to prove all the elements of the mens rea and actus reus. It's mainly where the actus reus is completed, and they're not required to prove the mens rea to a certain extent, because these offences are regulatory. We see these with road traffic offences, health and safety, and food hygiene, public regulation. So normally these offences are not classed as true crimes. They are more like regulatory regulations which carry fines. So the criminal justice system and the courts have almost removed the need to prove the mens rea. And we'll deal with that in a separate session. And with that said, we also have the notion of transferred malice. That's where a person has the actus reus and mens rea for a crime. We normally see this with assaults, and the sort of actus reus and mens rea can transfer from one person to another, or from one item to another. So we have the case of Latimer, where Latimer is in a fight in a pub, uses his belt to strike the person who he's fighting with. It misses the person and hits the landlady and injures her. In that case, the actus reus and mens rea is transferred from the intended victim onto another person, and the defendant is still liable. So that's called transfer. It's called the doctrine of transferred malice. Okay then. So if we go back to direct intention, and I explained that direct intention seems to be pretty straightforward, where the prosecution can clearly demonstrate that a person had an aim, a desire, or a goal to do something. That does not cause the problems. Where we do get a problem is where we have the area of oblique or indirect intention. And a definition of that from your CILEx book is where the result, for example, the victim's death, is not D's aim or purpose, but it is virtually certain to occur if D succeeds in achieving his or her primary aim or purpose, and the defendant foresees that the eventual result is virtually certain. And to put more briefly, we would say direct intention equals the aim or purpose, and oblique intention is D's foresight of a virtual certainty. What I recommend you do is learn that definition, because the CILEx markers are quite prescriptive. There have been a number of questions based on direct and indirect intention in past papers. One of the cases that you need to read about is the case of R.V. Woolin 1998. And Woolin is now the leading authority for the current definition of oblique intent. In Woolin, the defendant threw his 3-month-old child against a hard surface. The child eventually died. He was prosecuted, and he was charged with murder, and there was a number of appeals, and the House of Lords subsequently reduced his murder to manslaughter and gave a definition of indirect intention. So, and this was where the jury could find evidence of intention from the fact that the defendant was aware that it was virtually certain that these outcomes would occur. So please have a look at the Woolin case in your reading, and you will probably be required to recall the Woolin case in the exam. So the next stage is we talk about recklessness. This is where a person enters into a risk-taking state. There are two types of recklessness: objective and subjective. Objective being, what does the general person think? What do people think at large? What would the reasonable people think? And the subjective test is, what does that individual think? What did the defendant think? Did the defendant think that they were risk-taking? That's called subjective. The CILEx book actually says, objective recklessness is where D takes an unjustifiable risk that is obvious to a reasonable person. The subjective recklessness is where the defendant takes a risk which he himself realises is unjustified. There are two tests for recklessness. Both are subjective. One is the case of R.V. Cunningham, 1957. This is where Cunningham removed or damaged a gas meter that was operating in the basement of a building. And this was in the 1950s, when the gas meter was operated by putting a 10p into the machine, and that released a valve that opened up the gas. He wanted to remove the storage box which contained the money, and in doing so broke the pipes and caused noxious fumes to be sort of ingested by a neighbour. And he was charged with some offences in relation to that, and subsequently acquitted because he failed to know that there was a risk. So this again goes on to talk about risk taking and the idea of a subjective test for risk taking. Was the defendant aware there was a risk, and that subsequently was that risk unreasonable? So in the case of RVG and another, this is a case where you'll read two boys set fire to some wheelie bins near to the co-op at Newport Pagnell and caused £1 million worth of damage. The old test for damage was an objective test. What would the reasonable man say? This was found to be unreasonable for children and people with learning difficulties, so the House of Lords modified that. So for criminal damage, the test for recklessness is a subjective test. It's a modification on the Cunningham reckless test. It says that the Lordship stated a person acts recklessly with respect to a circumstance when he was aware of a risk that existed or would exist, and result where he is aware of a risk that it would occur, and it was, in the circumstances known to him, unreasonable to take the risk. That's the big difference, unreasonable to take it. Therefore, recklessness involves the conscious taking of an unjustified risk. So, there are two tests when you do the reading, very important. The first one, which is a general recklessness test, R.V. Cunningham, is subjective recklessness, and we see this in all the offences apart from criminal damage. And in criminal damage, we have another subjective test called RVG and another, and this is where it is unreasonable to take the risk. It is important for you to study the hierarchy, be able to explain the hierarchy under exam conditions, because in the first section you are definitely going to get some short answer questions on this topic. Usually you're going to have to demonstrate some knowledge of Nedrick, Woolin, Cunningham and RVG and another. RV Nedrick was an earlier case which was based on a man who poured paraffin or petrol through a letterbox, set fire to it and killed a child. And again, this was this virtual certainty test in its embryonic form. That was then almost replaced, or was replaced, by Woolin. So Nedrick provides some historical background, but Woolin is the leading authority. RVG and Cunningham are still leading authorities for recklessness. So I advise you to pay some particular attention to mens rea, because it crops up throughout both of the papers. Thank you.